Before we read the final orders, I would now allow my colleagues to read their dissents. And I'm requested to start with Justice Ojwang. Thank you.
I so proximate to the moment of delivery of the Supreme Court's decision in this pivotal case, did I learn that I fell on the minority side. By the Constitution, the timeline for hearing and determination was below a fortnight, and so full versions of the judgment had to come later. My summarized dissent thus grasped only the compelling elements of the case. Today, I have the opportunity to set out my opinion in detail. The question before the court was whether the presidential election conducted under one and the same electoral process with 5 other sets of election for the Senate, National Assembly, county governors, women's representatives, and county assemblies had been so compromised by operational irregularity and illegality as to compellingly attract orders of annulment. I learned that the majority on the bench had come to the unreserved resolution that the presidential election was a nullity and that the electorate must return to the polls. The position is summarized in orders which have been given on the majority side, indicating precisely what was decided. Thus, vital issues turning upon the democratic principle, issues of the terms and essence of the Constitution, of the statute law, and of the judicial mandate in the interpretation and crystallization of functional dimensions of the legal process had been so cursorily dispatched, maybe in answer to policy objects or to political persuasions or to other general social calls. For me, as an experienced lawyer and judge, but more particularly as a dedicated legal scholar, such an approach to contentious matters did short shrift to the firm and principled normative configuration of the law and the legal process, elements which alone would temper the motions of the social and political order and ensure that the mechanisms of governance remain attuned to the ideals of civilized process. I will, in this judgment, examine the foregoing dimensions of law with greater focus after adverting to the pertinent issues and evidence in the whole course. Now, there was the main course brought by the petitioners, and there was the prelude. The petitioners were the presidential and deputy presidential candidates of the National Super Alliance coalition of parties and were running on the Orange Democratic Movement Party and the Wiper Democratic Movement Party tickets, respectively. The first respondent is the Independent Electoral and Boundaries Commission, an independent agency established under Article 88, as read with Articles 248 and 249 of the Constitution of Kenya, and the Independent Electoral and Boundaries Commission Act 2011. The first respondent bears the mandate of conducting and or supervising referenda and elections for any elective body or office established under the Constitution, as well as any other elections provided for under the Elections Act. The second respondent is the chairperson of the first respondent and bears the mandate under Article 138(10) of the Constitution to declare the outcome of the presidential election and to deliver written notification of the same to the Chief Justice and to the incumbent President. The third respondent is the incumbent President, who was the candidate of the Jubilee Party and who was declared the winner in the elections on the 11th of August 2017. The petitioners are aggrieved with the mode of conduct of the presidential election of the 8th of August 2017. They contend that the said election was conducted, administered, and managed improperly by the first respondent, and that such mismanagement was deliberate and systematic, and having the effect that there was failure of compliance with the governing principles prescribed under Articles 1, 2, 4, 10, 38, 81, 82, 86, 88, 138, 140, 163, and 249 of the Constitution, with the Elections Act, with the regulations made thereunder, with the Electoral Code of Conduct, and with other relevant provisions of the law. The petitioners call for the invalidation of the second respondent's declaration of the third respondent as a duly elected candidate. The prelude to the main course is marked by a set of preliminary applications. I don't have to go to those. I've listed them, so you will be able to read them for yourselves. It was the petitioner's contention that during the presidential election, being part of the general election of the 8th of August 2017, certain management improprieties came to pass, which affected the registration of voters, the votes cast, the vote count. One of the allegations related to the category of votes described as rejected votes, said to have constituted 2.6% of the total votes cast. The issue being raised in this regard came alongside a contention that an earlier decision of the Supreme Court of 2013 should be reversed, insofar as the court had in that case held that spoiled votes are not to be taken into account in computing the 50% plus one vote strength threshold for determining the winner in a presidential election. Such a claim is founded upon a desired legal yardstick, rather than on the prescribed and operative law. The petitioners contended that the Supreme Court, in the earlier case, had improperly arrived at its legal threshold because it had been influenced by a dissenting opinion in a comparative case citation noted by this Supreme Court, which by Kenya's Constitution, Article 163(7), is the ultimate judicial authority, and, quote, all courts other than the Supreme Court are bound, end of quote, by its decision. The petitioners were invoking the case from Seychelles, Popular Democratic Movement Against Electoral Commission of 2011. They were urging that the majority stand in that case should determine this Supreme Court's position as regards spoiled votes in the electoral process, and that in that context there was an impropriety in the presidential election vote count following the election of the 8th of August 2017. The petitioners contended that the conduct of the presidential election of the 8th of August 2017 had contravened the principle of free and fair election under Article 81E of the Constitution, as read with Section 39 of the Elections Act and the applicable regulations. The burden of the petitioner's case lies on the process of relaying and transmitting voting records from polling stations to constituency tallying centers and the National Tallying Center. They questioned this process as falling short of the standards on simplicity, accuracy, verifiability, security, accountability, transparency, promptitude. They contended that such shortcomings had compromised the principle of free and fair elections in terms of Article 81E subparagraph 4 and 5 of the Constitution. The petitioners attributed impropriety to the electoral process on a plurality of grounds, such as 1, that the data and information recorded in Forms 34A at the individual polling stations had not been accurately and transparently entered into the electronic kits at the individual polling stations. 2, that there had been non-compliance with the requirement that kits be accompanied by an electronic image of the prescribed forms as these were transmitted to the National Tallying Center, and this was in contravention of Regulation 87.3 of the Elections General Regulations. 3, that the first respondent had predetermined the results of the presidential election and was therefore not impartial, neutral, and accountable as required by Article 81(e)(5) of the Constitution. The declared results were not verified in more than 10,000 polling stations, and the data entered in the electronic kits was not consistent with the information in Forms 34A, that the information in Forms 34A was not consistent with that in Forms 34B, and the figures were not accurate and verifiable, that the computation and tabulation of the results in a significant number of Forms 34B was not accurate, verifiable, and internally consistent, that the results recorded in the first respondents' Forms 34B were materially different from those relayed and relayed again as at the time of filing on the website, that the first respondent had espoused a false narrative and national psyche as the stage for stealing the election on behalf of the third respondent by allowing the electronic media and the news channels to relay and continue relaying its results data which lacked a legal or factual basis, and that at the time of declaration of election result, the first respondent was not in possession of Forms 34B and did not publicly display the same for verification. The petitioners contended that the presidential election was not impartial, not neutral, not efficient, not accurate, not accountable, as required under Article 81(e)(5) of the Constitution, as read with sections 39, 44, 44A of the Elections Act and regulations made thereunder, and Section 25 of the IEBC Act, and that there were instances in which vote count had been distorted, manipulated, or inflated in favor of the third respondent. The petitioners asserted that it was impossible to determine who had won the presidential election or whether the threshold for winning the election was met. The petitioners contended that there had been a deliberate failure in the operational transparency and that the respondent had disregarded the decision of the Court of Appeal in Independent Electoral and Boundaries Commission against Maina Kiai, case number 105 of 2017, by failing to electronically collate, tally, and transmit accurate results, and by declaring results by county rather than by polling stations. The petitioners contended that the first respondent had allowed the transmission and display of unverified provisional results contrary to law, that the first respondent had also posted contradictory results in Forms 34A and 34B, and that there were internal contradictions in Forms 34A. They contended that the first respondent had declared final results on the 11th of August 2017, even before receiving results from all polling stations, and that allowed more than 14,000 defective forms from polling stations, with the outcome of distorting more than 7 million votes. The petitioners contended that the first respondent had colluded with the third respondent to eject their legitimate agents from various polling stations in Central and Rift Valley regions. On the basis of such allegations, the petitioners contended that the first respondent had abdicated its responsibility for ensuring a transparent and an impartial voting process, apart from corrupting the process of transmission of results. The petitioners contended that the first respondent had failed to adhere to the Constitution, rule of law, court orders and decisions, and that such a condition rendered the process of the presidential election, the transmission of results, and the final outcome a nullity, as it lacked integrity, fairness, transparency. The petitioners contended that there had been a violation of Article 86 of the Constitution and that the votes cast in a significant number of polling stations were not counted, tabulated, and accurately collected as required under Article 86 B and C of the Constitution, as read with the Elections Act. They contended that the results recorded in Forms 34A differed from the results shown in the first respondent's Forms 34B and displayed in the first respondent's website. And they asserted that the first respondent's Forms 34B were inaccurate, bearing statistical manipulation to favor the third respondent. The petitioners contended that the first respondent had acted contrary to the terms of Article 38, 81, 86 of the Constitution, as read with sections 39(1)(c) and 44 of the Elections Act and the regulations thereunder, as well as Section 25 of the IEBC Act. The petitioners contended that contrary to Regulation 7(1)(c) of the Elections General Regulations, the first respondent had fraudulently established secret and ungazetted polling stations wherefrom vote count results were added to the final tally, thereby undermining the integrity of the presidential election. The petitioners contended that a significant number of Forms 34B had been executed by persons not gazetted as returning officers and not accredited as such by the first respondent, and that such election results as were carried in such forms were invalid. They contended that all returns submitted without IEBC's official stamp or which did not bear the signatures and particulars of returning officers and agents were invalid. The petitioners averred that the returns used in a material number of polling stations were not in the prescribed Forms 34A, 34B, contrary to Regulations 792A and 87(1)A, and that the Forms 34B bore fatal irregularities affecting 14,078 polling stations out of the established 25,000. They contended that a number of the forms and returns were not signed, and they contended that some did not show the name of the returning officer, that some did not bear the IEBC stamp, that some Forms 34A and 34B did not bear the signatures of candidates' agents, nor the reason for lack of signature, that some were signed by some presiding officer serving at different polling stations. The petitioners contended that the first respondent had violated their rights under Article 35(2) of the Constitution by putting up inaccurate information which misled the general public. They also asserted that the presidential election was compromised by intimidation and improper influence or corruption, contrary to Article 81(e)(2) of the Constitution, as read with the Elections Act and Regulations 3 and 6 of the Electoral Code of Conduct. On the basis of the foregoing contentions, the petitioners formulated certain specific issues for the cost determination. These were: 1, whether the presidential election was conducted in accordance with the Constitution; 2, whether the presidential election was conducted in accordance with the written law; 3, whether the first respondent's non-compliance with the Constitution and or the law affected the result of the presidential election; 4, whether the first respondent's non-compliance with the Constitution and or the law affected the validity of the result of the presidential election. 5, whether the non-compliance, irregularities, and improprieties affected the validity of the results of the presidential election. 6, whether the non-compliance, irregularities, and improprieties affected the result of the presidential election. 7, whether the exclusion of 2.6% of the total votes cast as spoiled votes substantially affects and or invalidates the count and tally of the presidential election votes. 8, whether the total number of verified rejected votes should be considered in ascertaining the attainment by any candidate of the constitutional threshold. 9, whether the third respondent was validly declared as president-elect. 10, whether the said third respondent committed election irregularities. 11, what are the appropriate orders to be issued by the court? That brings us to the evidence question. What is the evidence? The various contentions and averments, as a matter of vital judicial methodology, are to be lighted up by objective evidentiary account. I will now consider the scope of validation for the petitioner's cause coming forth by way of their main body of factual testimony. The first respondent, Mr. Odinga, tendered evidence by his affidavit of the 18th of August 2017, which also represented the stand of the second petitioner. He deponed that he had been a presidential election candidate duly nominated by the NASA coalition. The first petitioner deposed that the first respondent, acting through presiding officers, undertook the vote count, which culminated in the declaration of the third respondent as president on the 11th of August 2017 with 8,203,290 votes as against the deponent with 6,762,224 votes. The deponent was aggrieved with the declaration as he believed the presidential election to have entailed breaches of the Constitution and the applicable laws. Such breaches arising before polling day as well as during the process of tallying and transmission of results. The deponent stated his belief that the presidential election failed to meet the constitutionally prescribed terms that require free, fair, transparent, accountable, credible, and verifiable elections. He deposed that the IEBC had deliberately and or negligently compromised the security of the Integrated Electoral Management System, the KIMS, and thereby exposed it to unlawful interference by third parties. He deponed that the collation, tallying, verification, and transmission of the presidential election results had been compromised by procedural flaws and illegalities upon such a scale as substantially qualified the credibility of the declared result. He averred that the poll results as declared were substantially at variance with the actual results tallied and declared at the gazetted polling stations. He deponed that the respondent, in concert with cabinet secretaries and others serving under the charge of the third respondent, had abused their positions by bringing their influence and pressure to bear upon the potential voters. The deponent averred that while the first respondent had acted by virtue of Section 44 of the Elections Act and developed the Elections Technology Regulations 2017, under which the KIMS system had been set up for the management of elections, The failings in the conduct of the presidential elections had now undermined the security of the electoral system, exposing it to third-party interference. He deponed that the said electronic system had been misapplied, with the effect that the presidential election was substantially conducted by manual processes. As an instance in that regard, the deponent averred that the first respondent acted contrary to law by failing to transmit electronically the vote count results from the polling stations and the constituencies, with the consequence that the transmission process was now exposed to unlawful manipulation. He averred, in that context, that the consequential delay in transmitting election results with the prescribed forms gravely affected the credibility and validity of the results. The deponent averred that a review of the election results in relation to the available forms 34A and 34B had shown substantial qualitative anomalies, such as put into question the credibility of the presidential election. The deponent averred that the third respondent was guilty of undue influence, bribery, inducement, and intimidation in relation to the free exercise of elective preference by the voters. In this regard, the deponent averred that the third respondent had, on the 2nd of August, at Makueni, issued threats to those chiefs who did not mount political campaigns in his favor, that the cabinet secretaries had actively campaigned for the third respondent, that the third respondent had taken decisions involving public resource deployment in such a manner as to benefit his political campaign. Another deponent, Ms. Oichoe, averred that she was a cybersecurity expert and had observed and followed the conduct of the 8th of August 2017 general election, in particular the process of vote count results transmission. The process, as she averred, entailed 6 primary scenarios in respect of which IEBC's operational systems and database had to be tested. The first was confidentiality, the second was integrity, the third was authenticity. There are a number of them. And as far as she was concerned, the first respondent had failed in all those respects, and therefore the transmission system was entirely questionable. Another deponent, Mr. Koitameto Lekina, averred that he was a duly accredited agent of the NASA coalition in the general election of the 8th of August 2017. He deposed that he had arrived at the IEBC coordinating base, the Bomas of Kenya, on the election date at 16:30 hours for the purpose of activating his access card. Following some delay in activating the card, the deponent joined the company of fellow agents and they witnessed the streaming in of election results, which commenced at 17:15 hours. Thereafter, he averred his team came to learn that it was not possible to verify the result announcements as they came unaccompanied with hard copies of Forms 34A or the soft copies from the server. The NASA team, being concerned, approached IEBC commissioners, Professor Gulie and Ms. Roslyn Akombe, and the CEO, Mr. Ezra Chiloba, calling for Forms 34B as a basis of verification. As this initiative proved ineffectual, the deponent averred the NASA agents demanded a meeting with the Commission and obtained yet another fruitless promise of access to Forms 34A, these being received with Forms 34B only in limited numbers on the 11th of August 2017. The deponent recorded his opinion regarding the unreliability of the supply of Forms 34A and 34B by the IEBC, that this was evidence of a determination on the part of the Commission to declare results that could not be verified as required by law. The deponent drew on the content of another affidavit by Dr. Oduo and averred that dilatory responses to the demands for the said forms showed the first respondents' announcements to have been misinformed and or based on information such as failed the test of verification, accuracy, transparency, credibility. Mr. Moses Wamuru, the NASA presidential candidate's chief agent and coordinator for Embu County, deponed that he and his agent colleagues had not only been harassed, but kept out of the polling station by IEBC officials and officers of the provincial administration for most of the election day. He deponed that he had been forced by the constituency returning officer to sign the election declaration form as a condition for being availed a copy of the election results. Another deponent, Mr. Godfrey Osotsi, for Amani National Congress of the NASA coalition, averred that he was an ICT expert who had been an observer of the August election vote tallying. This deponent deposed not upon the settled fact, but urged this court to order a system audit to trace transmissions so as to reveal the code used by IEBC for the more than 40,000 polling stations for the purpose of identifying the IEBC officers who used such codes to transmit election results, to establish the time and place where such transmissions were originated, and to identify the person who applied the special identifier to effect results transmission. The deponent also gave his opinion on matters of law, that under the Election Act, election material includes systems such as are contemplated under Section 17(1) and include the KIMS, which incorporates voter registration, voter identification, and the results transmission system. The deponent proceeds on that same line of averment. A declaration of results has to come in the wake of transmission in the right manner as prescribed before reaching the National Tallying Center. He rested his affirmations upon other deponents' statements in support of the petition. As at the time of declaration of presidential election results, only 29,000 forms 34A had been received, and their authenticity still stood to be ascertained, and election results could only be declared when the Commission was already in possession of all the forms 32A and 32B. The deponent averred that IEBC either lacked full control of its system or ceded such control to some other authority. Another affidavit was sworn by Mr. George Kegoro, the Executive Director of the Kenya Human Rights Commission, a civil society agency committed to fostering and safeguarding human rights, democratic values, human dignity, and social justice. He deponed that his organization serves as secretariat for an initiative known as Kura Yangu, Sauti Yangu, KYSY, which is wholly devoted to the cause of fair elections during Kenya's 2017 election cycle. He averred that KYSY had deployed some 500 agents in all the 290 constituencies to observe and monitor the electoral process, and KYSY had found contradictions and anomalies in the election data emanating from IEBC, especially in relation to the presidential votes as reflected on the IEBC website. An agent of the NASA coalition, Ms. Olga Karani, deponed that concerns had been expressed by members of the public about anomalies and irregularities in the vote tallying process. Such anxieties also coming from the election candidates as well as NASA agents. She averred that the prescribed election forms were manually availed to the National Tallying Center, though sometimes they were also displayed on the IEBC website. It was a belief that it was impossible to verify the authenticity of such forms. She deponed that by the time of announcement of the election results, the Commission had neither collected nor availed any of the Forms 34B, nor had it responded to outstanding issues regarding Forms 34A or to the questions being raised about results posted on the website. She attributed lack of transparency to the actions taken by the first respondent. Another deponent upon whose averment several of the petitioner's witnesses relied was Dr. Nyangasi Oduo. He deponed that on the 8th of August 2017 at 5:07 p.m., some 10 minutes after the closure of the polling stations, the first respondent started streaming results for the presidential election. He averred that such announcement of results had maintained a constant gap of 11% between the vote count for the first petitioner and the third respondent, notwithstanding the random distribution of the constituency locations. His averment expressed suspicion also on the basis that, as he perceived it, in numbers of polling stations within the central Kenya and Rift Valley regions, the petitioner's agents were chased away from the stations and replaced by imposters. And thereafter, presiding officers were caused to record fictitious results in favor of third respondent. Dr. Oduo averred that upon being asked by the petitioner to examine 5,000 Forms 34A supplied by presiding officers to the first petitioner's agents across the country and to compare these with Forms 34B supplied by the first respondent and Forms 33A posted on the first respondent's website, he found discrepancies. Dr. Oduo made averments embodying opinion in clear terms. He asserted that the third respondent and the deputy president, who were candidates in the presidential election, were guilty of corruptly influencing voters in the run-up to the general election of the 8th of August 2017. He averred that the election was compromised by instances of undue influence, inducement, bribery, intimidation. The deponent, in a second affidavit, avers that certain anomalies had compromised the said election, instances being forms marked with a rectangular rather than an official circular stamp, returning officers failing to sign Forms 34B or recording their own names, lack of handing over notes, discrepancies in numbers of valid votes, unstamped forms, corrected figures noted on forms, agents not signing statutory forms, discrepancies in vote tally.